Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon are receiving early bird access to this episode. You have the opportunity to ask questions and interact with our speakers. If you have a question, please type it into the comments section below and we will be sure to address it. If you happen to be unable to join us live, episodes are released each week following the live broadcast. So be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Doug Dykes and Clayton Syfrett with us for our Superstar series. Papa Don loves to honor anyone who has a stellar outcome at trial using the cutting edge techniques by giving them a platform to share how the edge brought them to victory. Doug and Clayton practice personal injury, Social Security disability, workers' compensation, and hurricane claims law in Florida. We will put a link to their website as well as their contact information in the description below, so you can reach out to them directly with any questions after this episode. All right, Doug and Clayton, tell us how you used edge techniques to achieve justice for your client.
Hey, thank you, Jenna. I want to start by saying that this was Clayton's case, and he did a phenomenal job. But we did implement as many of the edge techniques as we could, and there was a host of them we used. I'm going to let Clayton give you the overview of the case. And you're going to see one of the first things come into play was using focus groups to overcome the obstacles. And Clayton had more obstacles in this case than the obstacle course you used to run in elementary school. So I'm going to let Clayton get you going, and going to hear about focus groups, going to hear about social media, all the things that plague a plaintiff's lawyer in the year 2021. So Clayton, tell them a little bit about the case and some of those obstacles you hit as you were working through it.
All right. Well, thanks, Doug. Thanks, Jenna, for having me on the podcast. Thanks for anybody joining. This case, it had, Doug's right, it had a lot of obstacles, and we did use focus groups on many of them. One of the very first ones was social media. My client, unfortunately, loved Facebook, and his entire life was on Facebook. Everything he did was on Facebook, legal and not legal things. There were actually alleged drug transactions on Facebook. There was alleged doctor shopping on Facebook. There was discussion about what the money from the case would be spent on Facebook. And by the way, mine and Doug's contract says close down your Facebook page, but of course that was not listened to. And so there's a lot of hearings that happened. We had 21 hearings the week before the trial, not to mention probably 30 before that. But the focus groups really helped. And the focus group class, which I've had through KTI up to advanced, it really helps. Doug has a focus group courtroom that we use, and learning how to use the focus groups, I think, is really a big key. And I do it on so many cases now when I sign them up and try to figure out what's important. But it's also really, and that's kind of the macro focus group, like, well, what do you think about the case? But the micro focus group is, okay, here's a text my client sent that got posted on Facebook Messenger and the defense has it. What does this text tell you? And how do you deal with it? Okay, and then the next question might be, well, if we dealt with it this way, would you accept that? Would you think we were lying? Does that sound reasonable? And we tried our best to let the focus groups tell us how to handle these pitfalls. In fact, we used another KTI member, Elizabeth Larrick, who did a wonderful job of prepping our client over about a 3-day period on how to handle these pitfalls. And at one point in the trial, the defense lawyer was asking our client about all these problems he had from drugs to arrest, criminal record, arrested for selling his prescription medication while the case was pending, 60 hydrocodone pills. And the client did such a good job on the stand, the defense attorney said, well, Mr. Straub, you seem to have an answer for everything, don't you? And he really did. He did a great job. And if you don't know Elizabeth Larrick, or if you do, she does a great job, and she can help with client preparation. And it's just sort of something to offload of us because we get so busy on different things. I was sitting here thinking when we were getting started about and we have a PowerPoint we want to go through, but just kind of talking off the top of my head. So we talked about the focus groups and how important they were, but we also use a lot of other edge techniques. One of the ones we really tried to pay attention to, which you don't have a lot of time for picking that jury, you know, unless you're Don Keenan and you've done it 1,000 times, you'll be good to get 9 out of 10 of the items out of that pie down right, but they all do help. And it is important to go through them. And it's important to practice it. If you have time, focus group that too. But picking that jury is one of the most, you know, it is the most critical thing because those people decide the fate of your case, and trying to ferret out the rats in the jury and get them off the jury. And I felt like we did a very good job of doing that. Bay County, where we are, is very conservative, not a lot of big verdicts. And we had 7 figures almost for pain and suffering for a guy that had gone back to work and had gained 100 pounds and, you know, hadn't treated at all in a couple of years. So the jury picked up on part of what we said, and I believe part of that came from picking the right jury, and that Keenan pie was part of that. Another thing that I think, and I'm a little new to Keenan program, but another thing that I thought really drove me in this case and many of my other cases, there's not a class for this, but it's preparation. And Mr. Keenan talks, and all this stuff is preparation and prepare. And every detail. And one of the details, and this is a section of Keenan, but witness preparation, you know, witness selection, and your bullet points for your lay witnesses. And we had I don't know, would we have like 5 or 6 lay witnesses that testified? This case, we had 21 witnesses take the stand. There were 6 experts that took the stand, 3 for the defense, 3 for the plaintiff, and the fees for the 6 experts was about $120,000 for 6 days of trial. It was a beast of a trial, but the lay witnesses, especially our client's ex-girlfriend, I had probably spent a good 6 hours with her, and it really probably wasn't enough, but I'd spent a good 6 hours with her, and she testified for probably about a good 45 minutes. But she gave, I think, probably the most meaningful, believable testimony, because our client, as you hear throughout Keenan, is your client is the worst source of information you can have, and you know the jury don't want to hear about your client. But when told through the eyes of someone else that's a real person, and our jury was 5 females, 1 male, and this was an ex-girlfriend that came in to testify, and she did a great job of looking that jury in the eye and telling them what happened. And it was because I believe that I had the Keenan experience, and I'd spent enough time going through the details with her and listening to Mr. Keenan and everybody else talk about how important it is to get all these details and spend time with people on more than one occasion. And so if I was really going to, you know, that's a real big deal. You get these experts that come in and they're just whores, and I think the jury knows that. But these lay people, they don't have a dog in the fight. The jury was leaning forward, listening to every word this girl had to say. And we had some other people that came in, and we linked them with photos. Visuals are very important in Keenan's world. And we made sure we had a lot of visuals. We had a lot of photos of our client doing things before he got injured, and how his life was. And so we used the lay witness to say, okay, what was this fishing trip? What was this hunting trip? And of course, our client couldn't do those things after. I've kind of been going on for a few minutes, but I can go through our PowerPoint. Doug, you think you want to roll with that for a second?
Yeah, let me just briefly, this was a forklift on pedestrian case. And one of the interesting things about it, which you're about to see, is liability was an issue from jump. And basically, as you're going to see in the photo in 2 seconds, when the wreck happened, Clayton's client wound up on, quote, his side of the line, and the forklift, wound up on, quote, its side of the line. But it was clear as a bell that they did make contact at some point. So one of the hotly contested issues was, where did the wreck occur? And then another issue was Clayton's client did not have on his high visibility safety vest. And y'all need to remember the word high visibility safety vest, because you're going to see on the jury verdict at the very end of this PowerPoint exactly how much it costs not to wear a, quote, high visibility safety vest. So give them that background, Clayton, so they can get the context of the wreck, and then kind of how that was in such dispute.
Okay, glad to. And I tell you what, maybe the easiest thing to do here is go ahead and share my screen, if that's okay, so I can give people that are seeing this understanding. Okay, so this on the screen is a forklift with a roll paper clamp in the front of it. It doesn't have your standard forks. And the forklift was heading towards where the cameraman is, and it is in its lane of traffic here. And then our client is laying on the ground, and the question is, you know, what happened? And there's no video of this crash. And so the defense was that our client walked in front of the forklift. That our client got out of his truck right here that he was driving. It looks kind of like a semi truck, and he walked down this road, and he crossed in front of the forklift. And our claim was that our client was on his side of this yellow line, and the forklift came over and hit him, and he was traveling too fast, and the driver of the forklift couldn't see him because of the mast. And there are so many problems. One, this picture right here, forklift's in its lane. The other problem is everybody here has got on what's called PPE, personal protective equipment, which is required in any OSHA setting. And our client wasn't wearing this $15 high visibility vest. And then, in addition to that, the defense produced 4 years after the crash, literally a witness that works for the defense, still works for the defendant employer, and said, oh, well, your client, while he was laying on the ground, told us this was all his fault. And so they had what they said was a confession that our client made. And again, they had an investigator go to the hospital to supposedly take a statement for our client, said the same thing. And this is one of the things that we focus grouped a lot. I focus grouped, okay, do you believe this? And pretty much unanimously, the focus groups told us that they did not believe the confession story. And I don't think the jury did either. What happened though, the negative thing that Doug's talking about is the jury did put a lot of fault on our client for not wearing a safety vest. And in hindsight, I did not focus group that correctly. And I should have thought about that point better. The driver of the forklift in the trial said on the stand, he said the vest would not have mattered because I never saw the guy. And so we thought, well, we got them. They're not going to put any fault on our client. But they put 48% fault on our client because he wasn't wearing a vest. And when I focus group this, I asked the wrong question of the group. I asked the question, well, was Johnny would it have mattered? And they all said, oh, no, we don't think it would have mattered. But the correct focus group question should have been, okay, granted, you don't think it would have mattered, but how much would you blame the plaintiff when they didn't do the right thing? He didn't have on his safety vest. And how much do you blame the defendant? And I imagine what I would have found is they would have said, oh, well, it's 50-50. The plaintiff didn't do what he was supposed to do. He's 50-50 at fault. And the driver, they're 50-50 at fault. So, and that's really what the verdict came out to be. And Doug's own daughter, who sat through the trial, we asked her, remember that, Doug? We asked her what she thought, and she told us, she goes, I think it's 50-50. And we're like, how can you say that? Because the driver of the forklift said, oh, it wouldn't have mattered. But the jury didn't care about that. The jury looked at it like, it might not have mattered, but we're not going to blame this forklift driver for all this crash when the guy, he made a conscious choice not to put on his personal protective equipment. It doesn't matter really, would it have mattered? He just didn't do what he was supposed to do. And the jury really handed it to him. In fact, the total verdict was, I think, $1.43 million, but they put 48% on him. And when they read it, I leaned over to my client and I said, that $15 vest you didn't wear, I said, it just cost you about $750,000. And worse than that, it cost me $280,000. So I was mad at him too. But, I didn't see that coming. And I should have thought, it doesn't matter. When you're doing your focus groups, you really ought to think about that. Even though I had them put it down on a verdict form, it's not, okay, what was the cause of the crash so much as, okay, who do you really blame for this? How do you see this in the big picture? And so I learned something from that. I was going to go back to the beginning of this. This is the PowerPoint that Doug had our office do. But we talked about our obstacles. This doesn't even show all of them. Our client had a confession twice, once at the scene. We focus grouped that. Where was the impact? Our client's criminal history.
Let me throw in one thing about the confession, if I may.
Sure.
Clayton took the gold from the focus group about this, quote, alleged confession, which was, well, did you write it out? Did the gentleman sign it? Did he get a copy of it? All those little, what I call gold nuggets from the focus group, which are making the most sense to them about whether or not this was believable. And those were the bombs thrown at this witness on the stand. And, he didn't have an answer to them. He couldn't explain it. It wasn't done. He didn't have it done. And so I think that resonated very well. And it certainly came straight from Bubba, if you will, about, well, you can't hold this guy to this. If this didn't happen, that didn't happen, this didn't happen. And so that was just a wonderful use of letting the focus group tell you what's going to matter. And we've heard it 1,000 times. We don't think correctly as far as how they process information and how they analyze stuff. So I just really think that I think that was a big, big deal, because if you chose to believe that, Clayton's client deserves zero. I mean, so that was just a big, big deal in my mind. And I also want Clayton to talk to you a little bit about the opening statement, which we crafted specifically from the advanced opening statement course, trying to do it the right way. And that was the impression that the jury was left with at the conclusion of Clayton's opening. The judge let us use it fully. There was four TV screens in the courtroom. And I'll tell you, when something goes up on that TV screen, it is like a magnet to the jury. They are completely focused on it. And during discovery, Clayton got a document. We called it, they call these things, they have an abbreviation called pit trucks or something like that, which is basically a powered industrial truck. This one was a forklift, but they train on them. And so he got some really, really good edge information out of that helped him with his statistic, helped him with his safety rules. And it was just, the defense could not run from it. It was their own document. And we know that's always good, because you try to run from it, you're just a hypocrite. So I just didn't mean to go too far, Clayton. I just thought that was significant.
No, thanks, Doug. I'll back up for a second. So the point Doug was talking about the writing, I was in one of my focus groups, and I had a what we call a shit happens juror on my focus group, and he worked in the oil industry, and he no matter what I said, he was not going to side with our client or give any money to him in the focus group, and he had an answer for everything. But one of the things in going through, and his attitude was, look, if you're on an oil rig, if you're at the port, if you're on a construction site, it's your job to avoid being injured. And there's people that believe that, and they can be on any jury. And so he kind of felt that our client, look, if you get hurt, you could have done something to avoid it. I don't care. That's the way these people, they're trained a lot of times. And so in talking to him about the statement, he at first believed that the defense probably got this statement from our client, both at the scene or at the hospital. And he maintained that. And then while talking to him, he said, well, your client, if your client didn't agree with the statement, he should have rebutted it when he got it. And I said, well, he never got a copy of it. He said, the focus group member said, what do you mean he never got a copy of it? And I said, well, they didn't give him a copy of it. And they said, well, did he sign it? And I said, no. He goes, oh, well, I don't buy that. He said, every case we're ever involved in, when they take a statement, you have to sign it. And he said, we've never had a statement given that wasn't signed. And he said, I don't believe it. Then he totally changed 180. But Doug's right. I got that from them. So at trial, we told them that. I wouldn't have thought of that. That wasn't something that I would have, because we see statements all the time. People don't sign them. I mean, there's statements in doctor's records, client patient history. It's not signed. But to this guy, that was a big deal. And when I focus grouped that later again to another group, they all said the same thing. So Doug is right about that. So the next thing that Doug brought up, which is a great point, was this right here. In opening statement, this is from our opening PowerPoint. And in one of their own manuals, it said that 80% of all pedestrian forklift crashes and all injuries involving a forklift, 80% of the time are with a pedestrian. And it's pretty obvious who's going to lose that battle is the pedestrian. And so it's a big deal to to this employer who ran the forklifts, hey, watch out for pedestrians. That's your number one possible thing to get injured with. And so we put that up on the board and we hit it hard throughout the trial. And I think it really did make a difference. As far as, kind of give you an idea as far as numbers go, when this case started, our client had a work comp longshore claim. Well, they paid out $100,000 for his longshore lost wages and medical. And then his employer sent a letter to the defendant's employer and said, hey, you owe us $100,000 because your employee ran over our employee. And the defendant employer said, we're not responsible. Your employee wasn't wearing his vest. And plus he confessed to it being all his fault. And so from day one, the defense in this case said, we have zero liability for this case. And so the longshore carrier for the plaintiff dropped their claim. They didn't even pursue it, although they did through us, but they didn't pursue it. And when we went to a mediation, their offer to us was about 25% of what we ultimately got out of them. And so the case was a battle the whole time. But things like this, we think made a difference. This number right here saying that 80% of the crashes involve a pedestrian, which this is straight out of the opening recipe, start with a statistic. And it was a beautiful statistic to start with. There was no way to get around it. And then we went through and we did this. We had these safety rules and we went round and round with them. And these are rules out of their own book. And so this one, I'll read it for you. It's safety rule number 1, and this applied to the forklift operator. To ensure safety of operators and other workers, forklift drivers shall look in the direction of and keep a clear view of the path of travel. And so that was in our opening. And then we beat up the forklift driver with this, and we said, you weren't following this rule. And there was nothing he could do. I mean, he got to the point where he just said, look, I just didn't see the guy. He sort of admitted it was his fault, but our client had his own problem because he wasn't wearing that vest. This was our second safety rule, straight out of the defendant's playbook. We got it straight out of their training manual. And it talks about the attachment on the front of the forklift, that it could be only so high because that was a big issue in the trial. And then we had a third rule that we hit them with about supervision of employers. And we actually got lucky and got the employer on the verdict form, and they put more liability on the employer, barely, than the employee that was driving the forklift. And this was part of the reason right here, safety rule number 3. And this just goes to show you one thing that I've learned from Keenan groups is, you want it to be a systems failure. You always want to try the systems failure. And this is a systems failure rule. It says basically the employer, to ensure the safety of the operators and other workers, the employers must supervise their employees on forklifts. And that rule is saying, hey, employer, your system says follow this rule, but you failed to do it. And so it is a system failure rule. And that jury, if you look at this, there's 3 people on that verdict form: the plaintiff, the forklift driver, and the forklift driver's employer. The guy driving the forklift that hit our client in the back with a forklift was held the least liable. So juries don't like to hold individual people liable. They'd rather hold a corporation or a defendant, and that's why you want to use a system failure case if you can, because they just don't like holding individual people liable. And then finally, we had our bumper sticker, which is also, straight out of the openings. The bottom line is forklift operators must steer clear of other workers. And we hit that throughout the entire case. This was part of our PowerPoint, made it very clear for them to understand, starting off, so the jury knew what the case was. We had visuals in the PowerPoint. This is a picture of the scene. where this happened. You can see the forklift after the crash, other photos. So the jury, we wanted to make sure the jury knew going into this exactly how this happened and get the big picture. And this is a picture of where one of the main eyewitnesses worked. We want to know where her point of view was. So when they heard Joe, her name was Joe Young, they would know why she was important to the case. So they weren't surprised. This is the photo I showed you earlier. This is the defendant's co-employee standing around, the defendant on the ground, or plaintiff on the ground. All these photos, this is the actual PowerPoint that we used in the trial. And again, this is straight out of the recipe for Keenan openings, who we are suing and why. And the defendant's name was SSA. So the employer, SSA mechanic, for violating safety rules. That was the forklift driver. We didn't use his name. We referred to him as a mechanic because he wasn't really even a forklift operator, which I think that might have been Doug's idea. I thought that was a really good idea. And then the defendant, SSA, the employer, failed to properly supervise its employee. And then continuing the rules. Did they follow the rules? No. And why he didn't follow the rule, what he did to violate the rules. And then we went through, we went ahead, and in fact, in our case, we brought up every negative point the defense had, whether it was social media, criminal activity, drug use, no vest. We brought it out in our opening, and we even called all the defense's witnesses except for their experts. So the only witnesses the defense had to put on the stand were their experts. We called them defense excuses. He didn't have his vest on. They claimed that our client confessed. We talked about that in the opening. They said that our client didn't follow doctor's orders, that he had gained too much weight, that he didn't try hard enough to get a job. We talked about it, all those things in opening. Timelines are great. This one's a little busy. I would rather, do it a little better, but this was important because there was an issue about our client using his medication properly. UDS is a urine test, urinary drug test. And their claim was that he wasn't taking his medication, and actually that he was selling his medication. And so all the blue ones are when he passed his drug screen, meaning he had his medication in the proper amount in his bloodstream. There was only 3 where he didn't, and we had a good explanation for that. And we focus grouped it. And the explanation was that our client had gotten a prescription for roughly 30 or 60 or 90 hydrocodone pills at the beginning of the month. And at one point, they had reduced it from 3 a day to 2. And so shortly after that, he failed a drug screen. And his explanation was that he ran out, that he'd had back pain and they'd taken his medication and he ran out before the end of the month. So when he went to the doctor, he didn't test positive. And you fail the drug screen if you don't test positive. And it was basically the same explanation the other 2 times that he had run out. And the focus group said, hey, we believe that. And I felt that it went very well with the jury, us explaining that, as opposed to the implication he was selling his drugs. I don't think they would have given him a dime if they thought he was doing that. We used charts and graphs. This is a chart of his weight. And he's a big boy. He got up to 475 pounds at one point. But we use this to kind of show that with his injuries, he wasn't able to work out like he could and exercise, and it caused him some weight gain. And we had explanations for that. We had an employment timeline that we used that showed that he got jobs when he could, that he was still out there working. That was the purpose of this. And had the client go through it on the stand. and the client explained what these jobs were and what he was doing, these are not evidence, they're demonstrative, so the jury can't take them back in the jury room, but it does show that he was working and had a job most of the time. And I think the jury was picked up on that. We picked on the defense for challenging the plaintiff's credibility. And, you know, in focus groups, you'll find that people don't like it when you get to read people's private messages. And clients to this day don't like that. And even if you sue somebody, people don't like it. And so they got his private messages. And so one of the things that we realized through focus groups is juries don't really like that. They don't like it when you're, you know, digging around in people's private messages that are supposed to stay private. And so we pointed that out, and we brought out the messages in our case in chief before the defense had the chance. And so they didn't even get to really ask him anything about it. We explained everything, and that was wonderful. Had they gotten up there and been able to go through it and been shocking information, it probably would have been pretty detrimental to our client's credibility. But and that's what they were trying to do. But we knew through focus groups that the juries didn't really like it when people did that. And so we brought it out, and it kind of made the defense look bad in our opinion. There was a lot of social media problems we talked about. This is just some of those messages that we had to deal with, but we brought them out on direct, and I focus group the explanation, and Elizabeth Larry prepped our client on it, and it all went very, very well. We had a PowerPoint about the damages, the injuries, and they went through every single injury. Had 7 different body parts that were injured, and went through each one in opening, all the way through the trial, and then through closing. The jury definitely knew what it was. We had visual aids. This is from a medical illustrationist. Keenan's actually got somebody that does a better job than this, but this is somebody that I had before I'd gotten in KTI. And for every injury, we had a medical illustration done, and that we had shown it to the defense long before the trial started and gotten approval that we could show it as an exhibit. But for every injury, this was the shoulder, this was the elbow, compression of the ulnar nerve, meniscus tear in the knee. Those were the 3 main body parts that he had. Again, a visual aid about past wages, future medical bills, future lost wages, loss of enjoyment of life. And then we talked about our experts, and we, you know, every aspect of the case was covered in opening argument from start to finish. We told the jury what our experts were going to say. This was Dr. John McKay. He was our wage loss expert, and he told the jury it was somewhere in the $1 to $1.5 million range. We went ahead and gave them that number up front so they wouldn't be shocked later. We had a life care planner that talked about her expectations and lifelong numbers, $3 million. Put it out there in front of them. Don't surprise them. Talked about the fact that he had workers' comp, Longshore, that he owed them $100,000. And this was also important. We talked about the fact that this was his one chance, that the jury was important. And Keenan talks about empowering the jury, letting the jury know that they're in charge. And we told them up front in the opening and in voir dire, you know, you guys are in charge, and this is our client's one chance to make it. And you have the power to decide what his fate is. And we told him that. In fact, that's what the PowerPoint says. You will decide what happened. And then we used Keenan's quote from one of his openings. Now let's get to work. I think that was the playground accident case where maybe the girl was crushed under the tree on the slide. And then this was the ultimate verdict. I apologize, I was wrong. They put the defendant and his employer, they put it 30%. The employer alone was 22%, and our client was 48%. And this particular jury, they we put a lot of talk on there about future medicals, but the jury basically said it in our mind, and we had some discussions we sort of through later with the alternate, that they felt like, well, he loses some weight, he'll be okay. And so they didn't really buy into everything we laid out there, but they did put a number of $1.433 million in damages, which in Bay County, very conservative area. Doug and I had a goose egg trial about a year before this, for less than a year. So we were happy to get this verdict for sure.
I can tell you unequivocally that was the largest verdict in Bay County that day, guaranteed.
I mean, I don't know. I asked the clerk of the court how many seven-figure verdicts they get. And he said they don't track them, but he couldn't remember one in recent years. So, you know, I can stop sharing my screen here.
I want to, Clayton, real briefly. Well, I don't know. Go back to the opening statement PowerPoint. I want to just highlight a couple of things real fast for our people that are kind enough to attend, KTI people. I want to show them just a couple of things in the PowerPoint. Go back to the opening one if you could real fast. And then Jenna, I don't know if we put them to sleep or if they've just held all their questions. So
no, we haven't had questions, but that usually means people are just interested in what you're saying and they're picking it up. So I have a few comments if you want me to pepper them in, you know.
Yeah, go ahead. I was going to talk just a second about the PowerPoint, but go ahead while he's getting it up. And but
is that the screen you wanted, Doug?
No, I want the opening statement. I want to show the focus group something. She's going to show the attendees something. Yeah, go to safety rule number 1.
Okay.
I realize when we go to all of our training classes, you know, we have the right to expect and boom, 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 boom. And that also we talk about it's to protect us all from injury and death and everything. But one of the things that Clayton and I were working really hard to do was just keep it right on their playing field. So we sourced everything, which I'm a huge fan of at the bottom. So Clayton knew from early on in the case that that this pit manual was coming into evidence. So we wrote the safety rules to specifically go right along with the pit program manual. And then you can see all of the citations to the different pages in the manual so that when the jury saw it, when the defense saw it, there was really nowhere anybody was going to be able to go to say, you can't do that or you shouldn't do that. And, you know, we talk a little bit about rhythm and we talk about cadence. And so it just and I mean, don't think for a second you're not scoring points, and you are, and the jury's reading that and they're like, yeah, it makes sense. Yeah. And it's their own rule. Yeah. So go on down, Clayton, to the next one about, keep going. Right there. The bottom line is classic power word, used in big red letters. The simple truth is power word, must practice what it preaches. So again, power word again goes into what I call the emotion stool. I'm not sure, but it's the lie, betrayal, hypocrisy. You know, they're supposed to be doing this. They're supposed to be training on it. So if they're not doing it, that's a problem. And then this was even before we knew that the statistic was powerful, but we now know that we are using it, you know, at least a certain number of times in the opening. I won't steal that from the advanced opening course, but we were able to put that back in there again. So I just wanted to point that out, and then go on down a couple more slides, Clayton. No, keep going.
Which one are you looking for, Doug?
Well, no, go back the one that showed the booth where Joe Young was.
All right.
Right there. Yeah. This was a big part of the case because Clayton had spent time with Joe Young, who was the only eyewitness other than what, Clayton's client said and what the forklift driver said. And basically this interchange booth is what Clayton's client had stopped to go to. And that's also about the area where the forklift was fixing to pass. So we wanted the jury to know straight up that the only unbiased eyewitness you're going to hear from, this is exactly where she was. And so when she looks out her window, she has the clear view. Go back up, Clayton, or I guess go down. Either way is fine. Right there. Nope. Back up just a grunt. Sorry. Slide. Yeah, that one will work. Slide 18. That is looking directly ahead. That's what she would see if you would, looking out that window, looking straight ahead. And again, that's where Clayton's client had to walk back to under the rules and regulations to leave the port with anything or to move it, if you will. So I just thought that was really good to have the jury right there and trying to explain a forklift pedestrian crash, motor vehicle crash, anything without some kind of visual for the jury to follow along with you is just almost a nightmare. It's just almost impossible to do. So that was just a couple things I wanted to point out. And I'll go back to Jenna and Clayton.
All right. So I had a couple of questions. I've noted down a few things. I noted focus groups, witness prep, jury selection. I also noted some a little bit more specific things like dealing with social media, negative attribution, system failure, statistic, safety rules, and addressing problems up front. KTI has specific colleges for a lot of these items, or if not specifically for them. For example, we have a college on focus groups, witness prep, and jury selection. Opening statement discusses a lot of these topics. How many of those colleges have you guys attended, and how did they help you in implementing these techniques in this trial?
I've had every one of those, and I use things from every one of them. The other one we didn't talk about was closing. I had kind of two closings in this case. You get about 45 minutes, and plaintiff goes first, and what you don't use the first time, you get to come back after the defense rests and gives their closing. And so the closing was another one that was powerful, because in the closing class they teach you about telling a story and making it something that the jury can relate to and give them something to go back in the back with. And so that's another class that I had that I absolutely used. I told a story about a suit my dad had given me and a tie that I had a little boat on my tie. And I said that the jury was sending the plaintiff off in a little boat for life and putting provisions in it. And I was trying to paint that picture, but and that's powerful. One of the things throughout all the Keenan stuff, all the courses, is give them a visual, let them paint their own visual in their head and give them their own visual. And so throughout the entire trial, we did a lot of visuals, but I've had all those courses, and Doug's had more than me. And most of them I've done the advanced course, and it's all really good because it's a workshop. It's a class, but it's a workshop. You get notes on it. They all intertwine, and all the people in it have done a lot of the stuff. So you kind of build, all your classes are like Legos. You just keep building on all the information that you learn. But Doug, you add to that.
the the advanced opening statement course, I had Brent Crumpton, and I can't remember if there was another instructor. I apologize if I'm not mentioning them, but it was just really, and again, I like all the courses. I've had them all, and I'm still taking what I can take. But the advanced opening statement course pulls together so much of the background and the underpinnings of what we're trying to do. You know, we know from the what I call the overarching edge stool, which is rules, codes, and spreading the tentacles of danger / foreseeability. Well, you're doing that with that statistic. And then the very next thing that you're showing them is your safety rules. And then you're giving them the short story, and then you spread the tentacles of danger. I mean, so you are just hitting so many things of the core of what we're taught, but until you see it all and think about it from that perspective, it's hard to really understand, as Clayton says, the Legos. But once you have fumbled around with the Legos long enough and put them in the wrong spot enough times, it really starts clicking. And when it does click, it's a thing of beauty. And it's the symphony that we talk about, the Edge Symphony. So, you know, there's just so many little things that came up that, you know, some of you have know Mr. Keenan is very fond of the flip chart. And we were writing down pretty much everything the jury was saying as it was happening, making, you know, kind of the Bubba transcript. And so at closing, Clayton's able to say, you know, don't take my word for it. You know, here's what witness Jones said. Here's what witness Smith said. So that was another technique that was very effective. And I also want to point out we had discussions that things we were going to use, but then we didn't use because we thought ultimately that goes against some of the overarching themes. And I'll let Clayton tell you about the full size safety vest cardboard blowout you had made.
Oh, about the focus group. Yeah. So I took a picture of my client with and without the safety vest on, and my client was about 6'1", 350 pounds when this happened. He's, you know, and he had on a kind of a bright blue hoodie. And the defense was, oh, we didn't see him because he didn't have on his safety vest. And so I said, well, it's ridiculous. How can you not see a 6'1", 350 pound guy? And so I ordered off Amazon or somewhere a cardboard cutout blown up of my picture that was life size, 6'1". And so the discussion got to be, well, you can see that vest pretty good. That seems to make maybe a little difference. So I focus grouped that. And by gosh, the first thing they said is, yeah, you can see that vest pretty good. And I canned that thing. I threw it away. I didn't bring it out at trial. I threatened the defense with it, but I didn't use it. But focus group your stuff, because I'll tell you right now, it's not what you think. It's not about what you think. And I should have focus group the big picture on, okay, yeah, I'd talk my focus groups into putting 95% liability on the defendant every time. But I really should have focus grouped, okay, their guy wasn't paying attention, going too fast. Our guy didn't have on a safety vest. How do you blame them? And I bet you that probably would have got the right answer. It would have been 50-50. And that's about what the jury did. And I had a female co-counsel doing some motion stuff for me. And she said, yeah, that's kind of what I thought they're going to do too. So I got too hyped up on my own facts, but it still worked out good. And we definitely got more than what they ever offered us. And I had a lot of fun. This trial started on a Monday and went until Saturday. They had to open the courthouse up for us on Saturday. And it was, you know, it was a long week, but we learned so much. And I've already had one defense lawyer tell me on another case, he said, yeah, I think you two guys had me and Doug, we had the first jury trial in the state of Florida that I know of after COVID. And then we had the first one in one of the first ones in Bay County. And he brought that up to me. I didn't bring it up to him. So insurance companies know who's trying cases. They know who push it. And that's what you want to be. And their offers went up all the way up to and during trial. I finally quit negotiating with them because I wanted to see what would happen. But, you got to push them and they got to know you're going to push them. And, it's kind of what Keenan says, I'll get it wrong. It's like, tell them what you're going to do, show them what you tell them, and then tell them what you showed them or something to that effect. And that's what we did. And it worked out. It was work, but we got paid, and it was darn sure worth it. I'll tell you that.
One quick question before we wrap up here. You said you had a goose egg of a case there in that county in the past. What did you attribute the turnaround to?
Well, that was Doug's case. This was mine.
Who's first chair? I see.
No, I'm kidding.
Maybe I shouldn't have asked that question. I take it back. What do you guys
Doug, I'll let you take that one.
Sure. There's just a lot of the cases were just phenomenally different. The goose egg case was, car A hits car B, and it's at a stop sign. The POV of the jury is already with the defendant that they think they would be sued. Nothing injury-wise like what Clayton had. And, there were some, there were just missteps along the way that looking back, we're like, crap. We could not, and I know we teach it, or Mr. Keenan teaches, you can't blame the judge, but we weren't allowed to use any visuals whatsoever during our opening statement. And just a lot of things we weren't allowed to do. And we got liability. I mean, they put liability, they blamed our client, which I didn't think they should have in a rear-end crash. But anyway, in Florida, with a motor vehicle crash, unless you prove a permanent injury within a reasonable degree of medical probability. So in other words, they got to believe, Clayton clearly had it here. He didn't have that burden because it wasn't a motor vehicle crash. But when you have a non-surgical case, and it's just like the neck and the back pain, it's just a tough burden because the negative attribution, the jury wants to believe, well, crap, I could be in that kind of wreck. I'd want to be better. I wouldn't want this to be a lifelong thing. So anyway, and by the way, Clayton did give the opening statement during that one we lost too. So just so you know, he improved.
But Doug, I think.
So he shares some of the blame.
Well, but one thing you need to point out, Doug, and this kudos to you, is your offer before trial was what fraction of what they offered you during trial? Was it 6-1 or 3-1?
Yeah, I'm not sure where it happened. I don't know if the defense lawyers weren't paying attention, but the highest offer before Clayton and I went over there was like 12 or 13,000. It was just maybe 17.5. It was just stupid. So we're walking back the first day, and the defense lawyer looks over at me and says, "So your lady doesn't want to take the 50?" I said, "What are you talking about?" He said, "Yeah, we offered you 50." I'm like, "No, you didn't." And, "Oh, yeah, we did." And so he went home and he goes, "Crap, I never sent you that. I thought I did." I'm like,
well, and then I think he offered another 10. So I think the ultimate offer was 60. Hindsight, we should have taken it. But my point in this is pre-trial, he didn't have an offer of 20. And during trial, I'm pretty sure it was 60. So that was triple what it started out at. Mm-hmm. And until you take them to the mat, you're not going to get that best offer. I've never had money leave the table.
Yep.
And I've always had it go up every time. So
always going to come back with more.
Well, and what I did with that loss is I tell the That it doesn't get brought up, obviously, but I'm like, I'm still here, I'm still going, and I'm definitely due for the win now because I got to get that reputation back.
Mhm. I know, I think people sometimes don't realize, when you go to trial, it doesn't necessarily mean you have to go all the way to verdict. You have to get in the ring, though. You have to get in the ring. And if after your opening or after your client testifies or somewhere right before closing, you get the number that you want, which, by the way, for those of you listening, you learn how to figure out what number you want in your case in a Keenan Trial Institute course called mediation. So if you get that number, it could happen at any point during trial. So always consider trial to be part of the negotiation process. And the fact that you step into that ring is a huge, huge piece of leverage. So, all right, we are a little bit over, which I think we started a little bit over. So I think we're all right. But thank you so much, Doug and Clayton. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's video, please click that thumbs up and don't forget to subscribe and sign up for alerts so you don't miss an episode. Now, this podcast is about delivering what you want to hear, so don't be shy about sharing topic ideas with us. As Papa Don always says, if you want to know more about it, chances are someone else does too. Next week, we will be hearing from Greg Luther and Brent Crumpton as part of our New Revolution series. They'll be discussing what's new in the edge world of medical negligence. Now, this is an area that we've been incorporating in our law firm, so I look forward to learning from Greg and Brent along with all of you. Have a wonderful weekend, and I'll see you next time.